The more strike offenses you're found guilty of, the worse punishment you're facing. So if you're convicted of one strike offense and then convicted of another strike offense afterwards, you're looking at a more significant penalty based on having a current strike and a prior strike conviction. And then if you catch a third strike, you're looking at a life sentence based on that. It's very, very scary. We talk about strike offenses in other videos here, especially in the video on felony sentencing. I don't want to go too into the weeds as far as what counts as a strike offense in California. You might know there are two different types of strike offenses. You have serious felonies and violent felonies, and some type of charges count as both. I'm going to keep it simple and just talk about cases that I think a lot of people understand readily as strikes, like burglaries, robberies. Those are cases that I think people readily understand to be strike offenses. But what happens in a situation where somebody has multiple different strike offenses going on at the same time? What happens in that scenario? Is the person necessarily looking at life? Can you be struck out if hypothetically you get convicted of 3 separate strike offenses on different times? Well, it depends. One situation comes up in some cases where somebody might be involved in what prosecutors call a crime spree allegation, where a person is accused of committing multiple different strike offenses on different occasions. Let's keep it simple here for the purposes of argument. A person goes ahead and commits a burglary in January of 2022. They end up going to court, they get found guilty, and they're sentenced sometime in April of 2022. Then in May of 2022, they commit another strike offense. Let's say it's a residential burglary. In that scenario, that person will probably be charged not only with a current strike offense, the burglary of that's most recent, but they're going to be accused of committing that while also having a prior strike conviction on their record. The logic behind this is that they're being accused of a strike offense when they had already been found guilty of committing a strike offense in the past. That's where the crucial part comes in. If in order for your prior strike to actually count as a strike prior, you would have had to have been both found guilty of the offense and the actual offense conduct both has to predate the conduct date in the current case. It doesn't count as a strike prior unless you were convicted of it at the time of the conduct in your current strike case. So let's say, for example, a person commits a robbery in Alameda County in February of 2022. Then before they're even arrested, they end up getting accused, they end up committing another robbery in Santa Clara County in April of 2022. And then following that, in May of 2022, they commit another robbery up in San Francisco. However, in this situation, none of those 3 counties are legally able to sentence him as a third strike offender. So even if he gets found guilty of, say, hypothetically, the Alameda case, and then gets found guilty of the Santa Clara case, San Francisco is not allowed to look at him as a third strike offender. Why? Because remember, in this situation, San Francisco's case occurred, the actual offense conduct occurred before our hypothetical defendant was ever even convicted, actually, of the strikes that come out of Alameda or Santa Clara County. This analysis was clarified in 2003 in the case of People versus Flood, where the California higher courts clarified that you can only be accused of having a strike prior when that prior strike, conviction, and conduct both occurred before the alleged conduct occurred in your current case. If there's any type of weirdness with the timeline, for example, if you allegedly committed a prior strike, but you aren't convicted of it yet at the time when you're already fighting another strike case based on another set of conduct, they can't double you up and make those into strike priors into other cases. This is a really important distinction because it affects the ultimate question: what am I looking at when you're dealing with allegations of strike offenses under the 3 strikes law? When the possible penalties are so draconian, these distinctions matter a lot. It's also a lot different from how this questions of priorability work in California's DUI law. Under the DUI law in California, your offense counts as a prior as long as you were found guilty of the conduct and the conduct itself occurred in the last 10 years, it will count as a prior. There's none of this staggering going on that we have in 3 strikes law. But the 3 strikes law, you should only be legally worried about a strike prior if that prior strike offense was pled and proven at the time of whenever you allegedly committed your current strike offense. Hope this was helpful. If you or someone you know is facing charges under California's 3 strikes law, please feel free to give us a call.